Today's presentation considers the legal framework for mining in Africa in the context of its increasingly fragmented nature. Issues will be discussed around the conflicts of laws, agreements, and titles. I'm incredibly pleased and honored to introduce our presenter, Guillaume Blanc. Guillaume is an executive in the ENS Africa's Project Development and Project Finance Department. He specializes in project acquisition, development, and finance, as well as energy, utilities, mining, and petroleum law. Guillaume has gained more than 20 years of experience in law firms throughout the world, and he has advised clients in developing markets on the acquisition, financing, and development of energy, water, oil, gas, and mining projects across various jurisdictions. Guillaume is a member of the mining law and oil and gas sections of the International Bar Association. Thank you so much again for joining us, Guillaume, and over to you.
Okay, well, thank you very much, Aysha. I must thank the Institute for having this forum today, and good afternoon good afternoon, everyone. I thank the public for attending this presentation. So, although I understand I'm invited to talk to this forum, and this forum is hosted by a South African institution, I'm not going to talk a lot about South Africa, and I will primarily refer to examples that are related to other African countries, because I've gained my experience actually outside South Africa. But I think that what's going on outside South Africa is of interest for many members of the public. We're all interested in the development of mining in Africa, and one of the central topics that we can talk about today is the increasing fragmentation of the legal framework for mining in Africa. So what do I mean by this concept of increasing fragmentation of the legal framework? It is the idea that actually the legal framework, the legal basis of mining projects in Africa is more and more complex, more and more fragmented, in that it doesn't depend on one single agreement that would be a project agreement, but it depends on a multitude of legal instruments that must be understood, reviewed, and that must be covered in the due diligence exercise that we need to conduct every time. We need to look at the feasibility of a project. Otherwise, we may have a complete we may have a completely wrong idea of what is the legal framework that will apply to the mining project we want to develop or operate. So, in other words, I think it is important for any project, and even exploration project, to really understand that there is very often the wrong assumption that the feasibility of the project will mainly depend on the type of contract the sponsor will enter into with the host state, the state where the project is located. So it is true that 30 years ago, 40 years ago, it was the fundamental legal instrument that documented any mining project. Nowadays, it is quite a dangerous assumption that can be made, because the feasibility of mining projects depends on the articulation of many legal instruments, and not simply the applicability of one single instrument that would be the project agreement, and many legal instruments that are not necessarily of a contractual nature. So in other words, it is because we have a multiplicity of legal instruments applying at the same time, and very often conflicting with each other. And it is because we have legal instruments of a non-contractual nature that we can describe the legal framework for mining projects as a framework that is more and more fragmented and not consolidated in one single instrument that would be a project agreement or project development agreement. So this is the general idea of this presentation. So why are we talking about fragmentation of the legal framework? This is because we have a multiplication of the legal instruments that can concurrently apply to the development and the financing of projects. And it is because we are dealing with legal systems of a very different nature. We are dealing with legal instruments of a very different nature as well. And as I said, not only of a contractual nature, we are dealing with the classical conflict between what is documented by contracts and what is clearly outside the scope of contractual negotiation. But we also have a new generation of conflicts between instruments of a contractual nature themselves, between the agreements that are needed for the feasibility of projects, and also a conflict between their governing laws. So this type of fragmentation has also an impact in terms of contractual rights and also in terms of ownership rights. And this impact will be described in the last part of my presentation. So that's for the summary of what we are going to cover today. So I would say that that fragmentation of the legal framework for mining in Africa is due to multiple factors. So there is one factor which is that could apply to other industrial sectors, which is the very complex and fragmented nature of the legal history of Africa. So in that slide, you have a map from Jury Globe, which is a Canadian website, a map of the different legal systems that apply in Africa. I'm not saying that I totally agree with that map, but at least that map shows you how complex the legal matrix of Africa is, because we are dealing with legal systems that are extremely complex and cannot be classified easily. So this has an impact on the feasibility of mining projects, in that there are more and more projects that require to cross borders, in particular to build and finance the infrastructure needed for mining in terms of railway lines, electrical lines, dams, ports. And every time we need to cross borders, we may have to deal with legal systems that are completely different from one side of the border to the other. And this is due to the fact that in Africa, we have a multiplicity of legal systems that are all quite different. Naturally, the first category of legal instruments are the legal instruments that were already applicable during the colonial times and are still applicable. For instance, in Francophone and Lusophone Africa, the civil code that was applicable at the time of the independence is still applicable, even though it may have been amended. But you will see that nearly 80% of the provisions of that civil code are still applicable. So we are dealing there with, naturally, legal instruments that either belong to English law or to French law or to Portuguese law, and those legal instruments are still applicable. Then the second category of legal instruments are all those amendments of the colonial documents that were made after the independence. But on top of those colonial or post-colonial legal instruments, you have the customary rules or rights, the native rights, those sources of law that have nothing to do with the colonial history or the post-colonial history of the countries, but are actually rooted in the traditions, legal traditions of the African countries. That's another source of law that can apply. And in addition, you also have other sources of law, such as Islamic law, that can apply in particular in the northeastern part of the African continent. And you also have a couple of countries where the legal history is even more complex. For instance, South Africa, where you apply Roman Dutch laws, English laws that were inherited from England, and other sources of laws, plus all those new laws that have been introduced into the South African legal system after the new constitution that you enacted in the 90s. So you can see that we are dealing in the continent with legal systems that are extremely complex. It's true that a big part of the continent is still based on French law, another part on Portuguese law, another part on English law, but that's only true for the basis of many legal systems. But this doesn't represent the entire body of law that may apply in the continent. On top of those colonial rules, laws, or post-colonial laws, you need to take into consideration other sources of law that are more and more recognized, such as customary laws, or sources of law that have been actually introduced in the continent and didn't exist before. All those new laws that you have in Africa about Black empowerment, transformation, local content, have nothing to do with the colonial laws that may still apply, and represent a new generation of legal instruments that we have to deal with in the continent. So here again, this multiplicity of legal systems and sources of law is a factor that explains the fragmentation of the legal framework for mining. It is not true that it applies to mining only. Of course, it is a factor we have to deal with projects that are not mining projects, but I would say that it has an impact regarding the feasibility of mining projects, in particular because we need to cross borders if we want to develop and fund many projects, many large-scale projects in Africa. So that's the first factor that explains the fragmentation of the legal framework for mining. Another factor is actually the conflict that we have between the legal instruments of a contractual nature and the other legal instruments that apply to mining projects and that are of a non-contractual nature. So as I said, 30 or 40 years ago, a mining company that wanted to develop a project was probably focused on its ability to draft, negotiate, or review a project agreement, which was called in certain countries an establishment agreement, convention d'établissement in Francophone Africa, for instance, or state mineral agreement. Well, you can find different names, or concession agreement. You may find that name in other countries. And it was really the key legal instrument that was the legal basis for a mining project. And the mining company didn't have to worry a lot about the different pieces of legislation that apply in the country where the project was located, because it could, in those days, I think I would say till the end of the 80s, insulate the project from the legal system of the host state. So it has been less and less achievable to do so after the 80s for several reasons. And first of all, because the states, the countries have made the effort to legislate and to really draft and organize their legislation that it can actually regulate the mining sector, which means that many matters that could be included in the scope of contractual negotiation in the 70s are now exclusively governed by legal instruments of a legislative or regulatory nature. And inevitably, you end up having conflicts between what is included in the project agreement, the state agreement negotiated between the private sponsor and the state, and those pieces of legislation that apply concurrently in the country. But there is not only a conflict between the project agreement, which is of a contractual nature, and the laws of a legislative nature. You also have conflicts with the constitutional provisions that you find in the constitutions, which here again have been more and more revised and adapted to the needs of the contemporary needs of those states. You also have conflicts between those state project agreements and the international treaties that have been entered into by the states. So you have conflicts between the project agreement, which is still quite systematically required by the sponsors and the financiers and the lenders involved in the financing of any mining project, but you still have a conflict between that legal instrument of a contractual nature and legal instruments that are part of the constitutional or legislative framework. But you also have conflicts in the project agreement and the regulations, in other words, what we call in certain countries secondary legislation. And you have conflicts between the project agreement and other agreements that are needed for the development, or the financing of the project. So as you can see, you also have here another factor that explains the fragmentation of the legal framework, which is the fact that any mining project will not necessarily require only the drafting and negotiation of agreements, but it will require the articulation of those agreements with legal instruments that are not of a contractual nature, and more importantly, that will override the contractual provisions that you have in the project agreement, or the different agreements that are needed for the development of the financing or the financing of the project. So a first important conflict is the conflict that you have naturally with the international treaties. You have more and more conflicts between what is included in the project agreements or different agreements that are associated with any project agreement, and the international treaties that have been entered into by the whole state. So we can see that conflict with treaties that have been entered into to regulate the conditions of arbitration and arbitrability, with the treaties that protect the bilateral conditions for investment protection, the bilateral investment protection treaties. We can see conflicts between the tax provisions in the project agreement and the bilateral tax treaties that are entered into that have been entered into by the country where the project is located. We can see conflicts between the project agreement and the maritime treaties or the treaties dealing with the international law of the sea, when we have projects that require to use mineral resources in the territorial sea or maritime areas. So these are this type of treaties frequently apply to a part of the scope of a mining project and may not be compatible with the contractual provisions of the main project agreement. So I would say that we have this type of this risk of conflict in many parts of Africa. In addition, we have a new source of treaties that may have an impact on the feasibility of mining project and may not interact very well with what the parties intend to include in the project agreement, which are those treaties that have been issued by the regional legal integration organizations that we have now in Africa. So a good example is the OADA, the business law organization of Africa, which includes 17 member states, which are primarily Francophone African countries. So in that region where you have the applicability of the OADA treaty, the treaties, I mean, you have treaties that will regulate actually many parts of business law that are relevant to mining. So, such as corporate law, commercial law, transport, collaterals and securities, arbitration, insurance. So that body of law, we have a very important impact and effect on the ability of any mining company to develop mining projects in the member states of the OADA. So you can also find other treaties that apply at regional level and that override the national laws and therefore the agreements that are concluded at national level, such as the treaties or supranational directives that have been issued by the regional monetary organizations, such as the Western African Monetary Zone Authority or the Central African Monetary Zone Authority. You also have the treaties issued by the African Insurance Organization called the SAIMM. So here again, depending on the matters, you might not be able to freely negotiate with the state under your project agreement the type of rules that you want to apply, simply because you need to deal with treaties that have been entered into by your state and that your state cannot modify on its own, and that will necessarily override not only the project agreement and the contractual provisions that you have drafted and prepared, but also the national laws of the whole state. So, in other words, naturally, the freedom, the contractual freedom of the parties is now more restricted, because in addition to the legislation that applies in those states, you need to deal with international treaties, which have more and more an impact on projects, because they don't deal with administrative matters only. They deal, those treaties actually apply to commercial matters. So that's a first type of conflict that, of course, explains why the legal framework is fragmented. But in addition to that conflict between national laws and agreements and international treaties, you have more and more conflicts between the provisions of the project agreement and also the national laws, and on the one hand, and the constitutional provisions on the other hand. We can see that some project agreements have been challenged, for instance, in countries like Guinea or Ethiopia, by reference to the constitutional provisions, the constitutions of those countries, for instance. And I think that we will see more and more challenges based on constitutional provisions in the future. So you can see here that there is another source of conflict that we can see in many African countries with constitutional rules. But in addition, you have conflicts between the project agreements, naturally, and the different pieces of legislation. So it is a more classical conflict of law that is well known, because here again, when a mining company enters into a project agreement, it must be prepared to be exposed to a conflict between the project agreement and the mineral legislation, but not only the mineral legislation, I would say also all the other pieces of legislation that will apply to mining. And now in most of the African countries, there is a multiplicity of laws in all areas that will apply to mining projects. So in other words, instead of dealing only with the mineral legislation and the Ministry of Mines, a mining company nowadays needs to deal with the Ministry of Finance, the Ministry of Foreign Investments, the Ministry of Land, the Ministry of Agriculture, the Ministry of Employment, the Ministry of Transport, and naturally all ministries are independent from each other and have their own legislation. Yes, sorry?
Sorry to interrupt. People are struggling to see the specific writings of some of these more the lighter writing. So is there a way that at the bottom of your screen you'll see a little toolbar with a plus and a minus next to it, and if you just right at the bottom in the right hand corner, if you can just shift that bar towards the plus, it will increase the size, and then you'll still be able to see your slides, and it will just be slightly bigger for presenters.
But where is that button?
I'm trying to accommodate both your preference in terms of seeing the next slide, and getting it slightly bigger for participants to see. So in the corner there, I can see your very close. You can see a little plus symbol next to it's to your right.
No, I don't see it.
Oh no, it's at the bottom. Do you see 69%? Right in the corner there.
Which corner?
The right bottom right-hand corner. Yes, there we go. If you can just press the plus symbol right next to it, you'll be able to make it slightly bigger for people to see.
Okay. Oh, sorry. 1 second. One second. Is it better? Is that better?
It does look a little bit better. Yeah, let's leave it like that for now. But I will be able to. Okay, so I think that should be one more is requested.
Okay.
There we go. Okay.
Is that better?
Thank you. Yeah.
Okay,
I think
well,
that's fine.
okay, so can I move
Okay,
on?
thank you. Yes,
Okay.
sorry about that. Thanks.
So sorry for this interruption. So as we have seen, so we can talk about the fragmentation of the legal framework because there is a conflict between the project agreement and rules that should override the project agreement and even the pieces of legislation that apply to the host state, such as international treaties, constitutions, constitutional provisions. But there is also a more common conflict between the project agreement on the one hand and legislation on the other hand. Very often when you look at a mineral project agreement or state mineral agreement, you will see that this mineral agreement contemplates the eventuality of a conflict between this agreement and the mineral legislation. But the agreement remains silent on the potential conflict between the project agreement and other pieces of legislation that do not depend on the authority of the Minister of Mines. So, and it's always quite difficult to resolve this type of conflict. Yet, it is more and more common to have this conflict because many projects actually require the applicability of rights or conditions that do not depend at all on the legislation, but depend on other pieces of legislation that are outside the scope of the authority of the Ministry of Mines. So there is a conflict between the state agreements and the pieces of legislation. Then you also have the conflict between the state agreements and the regulations at central level. But with the growing trend of decentralization and transformation of African countries, you have a new source of conflict between the project agreement that is very often negotiated at central level and the regulations that are issued at regional or decentralized level. That's another source of conflict within the host state. And then, as I said, you have other sources of conflict, which are described in the following slide, which are related to the fact that many matters of relevance to a mining project are not actually matters that you can negotiate and that you can include in the scope of contractual negotiation, because there are matters of a regulatory nature. And here, those matters include not only the question of the licensing of the right to explore or mine, the entire permitting process, but those matters also include employment conditions, environmental conditions, tax conditions, the access to infrastructure, And for all those matters that naturally apply to questions of ownership or questions that have an effect not only on the mining company but on third parties, there is no way you can fix all the rules applicable by contract, because precisely there is an impact on third parties, or there is an impact on matters of public order or sovereignty that the state is not allowed to negotiate under a contract. And it's simply prohibited in many countries by the constitution itself. So this is why nowadays, when you want to develop or finance a mining project, but you don't really need to enter into a state mineral agreement. I'm not saying that the state mineral agreement is not necessary, but you need to deal with a cascade of approvals and permits, a multiplicity of permits and licenses that you will have to apply for, and that will be granted by many different ministries. It is particularly true for naturally the right to conduct mineral operations, but it is also true for all the associated operations in terms of transport, processing, export, road navigation. It is true for environmental licenses, land occupation licenses, tax rulings. Naturally, it is true for all the infrastructure access or use rights. And for all those different matters, the solution is not really in the project agreement, but the solution lies in the ability of the project company to apply for the permits and licenses that are needed, and to avoid disputes regarding the validity of those permits and licenses. And here again, that question of the validity and enforceability of those permits and licenses cannot be actually governed by a contract bilaterally agreed between the project company and the host state. But in addition to those administrative approvals, a mining project may require approval by the parliament when you want to give legislative force to the project agreement, sometimes by the administrative tribunal. For instance, the state mineral agreements that you have to enter into in Mozambique must be approved by the administrative tribunal that has jurisdiction. And in certain countries, you also need to deal with the judiciary powers of the judiciary tribunals. For instance, when there are disputes, because even the settlement of the dispute and the enforceability of the judgment or the awards will necessarily, even if that award is a foreign arbitral award, the enforcement of that decision, that award will require the cooperation of the judiciary tribunals of the host state. So this is why it's so important to understand that the legal framework for mining is less and less of a contractual nature and is more and more regulated, and depends more and more on the ability to actually combine legal instruments of a contractual nature and legal instruments of a non-contractual nature and of an administrative nature. So, but there is also another source of conflicts between which is different categories of agreements that are needed for the financing of development or completion of a mining project. So here you have a chart on this slide which tries to represent the agreements that are generally needed for the feasibility of most of the large-scale mining projects. And as you can see, there are many different agreements that will be needed to move a project from conception to completion. Some of them, which are colored in blue on the left-hand side, will be generally prepared, drafted overseas by the lawyers advising the lenders, the sponsors, and will be governed by English law very often. However, without the agreements needed for the financing. However, every time those agreements will deal with the collaterals, the securities, the guarantees, a part of the matters, including those agreements, will not depend on English law. They will depend on the laws of the country. that govern securities and collaterals, for instance. If you look at the agreements concluded between the sponsors and the SPV, the project company, in the past, those agreements could be governed by a foreign law and not the law of your state. But nowadays, with that growing trend for local empowerment, local content, it is more and more difficult for the SPV to enter into an agreement governed by English law or foreign law with the sponsors, because the host state tries to participate not only in the share capital of the SPV, but also in the share capital of the holding company. We have seen that attempt in Guinea and in Gabon, for instance, and therefore there is very often the expectation on the side of the host state that the agreements that will deal with the equity structure of the project and the participation of the sponsors will be governed by the law of the country where the project company is actually registered. Naturally, the project agreement, what we call here the host agreement or the investment concession agreement, are agreements that are quite systematically governed by the law of the country where the project is located. As for the energy supply agreements, very often the agreements that are concluded with a local or state-owned energy or water supply operator. So naturally, here again, the law of the state will apply. And even if we look at the construction of EPC agreements, because we need to deal with that growing expectation that there must be local empowerment, local transformation, there is more and more the expectation that those agreements will be governed by the law of the host state. And if you take the example of Tanzania, it is now quite mandatory to elect the law of Tanzania as the law governing those agreements, but we can see the same trend in Mozambique, where there is a decree that requires the election of Mozambican law as the governing law of the EPC agreements for a big category of infrastructure and resources projects onshore. And therefore, the parties have no longer the freedom to elect whatever foreign law they want as the governing law of those agreements as well. So as you can see, the scope for the applicability of foreign law has been reduced and is likely to be more and more reduced, and which means that the mining companies, the SPVs, the project companies will be more and more expected, if not required, to elect the law of the host state as the governing law of all the different agreements that are needed for the development of the project, if not the financing of the project itself. So as a result, you are dealing with a multiplicity of agreements that are not governed by the same substantive law, are not governed by the same lawyers, are not drafted and conceptualized in the same countries, and inevitably, this may generate conflicts and disputes because it is extremely difficult to coordinate, to consolidate a contractual matrix. This is the work that actually the in-house General Counsel will have to do, and it's not easy even for those in-house counsel and lawyers to achieve such consolidation. And this explains you why there are so many conflicts and disputes when we look at the history of the mining projects that have been developed in Africa. So I've explained the main categories of conflicts we have between all those different legal instruments that concurrently apply or must apply or are likely to apply to mining projects. So naturally, it has an impact. It has an impact on the freedom of the parties to actually negotiate the conditions of feasibility of mining projects. It has an impact on their contractual rights, and it has an impact on their ownership rights as well. So I don't know whether I have enough time to continue or whether I should stop here. I guess maybe I should stop here, Aysha, because I think we have already
well, we have
the presentation. Is that right?
I think that you can continue with your presentation. We have one question so far, which I don't think will take very long to answer. So if you wouldn't mind, maybe just
Okay, so I've only 2 slides that are left, and where I may repeat what I've already explained, but to explain the impact on that fragmentation on the ability to conclude agreements and project agreements, well, I would say that if we look at, I would like to explain how it works. I mean, if we look at the main provisions that we have in a project agreement and that are listed here on this slide, so you will see that there are many provisions like the main rights and obligations of the parties, or the governing law clause, or the arbitration clause, where the parties can certainly have a great level of freedom to actually choose the conditions they want to apply. But if we look at other provisions that we find quite systematically in the mineral project agreements, and here I mean clauses dealing with the shareholders' rights, the security devices, insolvency transport, for instance, or even enforcement of arbitral awards, those clauses will be more and more dependent on laws or treaties that apply in the country where the project is located. And therefore, the parties will have less and less flexibility when they want to choose the terms that they want to include in those clauses. And I've taken here the example of the UADA region. In all the UADA member states, all those clauses will not primarily be drafted on the basis of what the parties want, but they will be drafted, or they should be drafted on the basis of what is required by the by the OADA treaties, and we call the treaties the Uniform Acts that govern those matters. But I would say that even the clauses that are in the upper part of the slide, they are clauses that we can less and less agree freely, because there is here again an interference, a growing interference of the national laws. For instance, as I've said, the parties are less and less in a position to choose the foreign governing law they want to apply, because for many agreements they don't have, that they want to enter into, that freedom is not recognized under national law. As I said, in certain countries, you need to elect the law of the state as the governing law of the EPC agreements, or the water or energy supply agreements, or even the sponsor or participation agreements, the shareholders agreements, because the state or the state intend to participate into the equity structure of the project. So therefore, the parties are no longer in a position where they can, in all circumstances, elect a foreign governing law as a governing law of the agreement. If we look at the arbitration clause, traditionally it was a clause that the parties were able to negotiate freely without any consideration for the legal framework of the whole state, and in particular because, as you know, and as we know, the arbitration clause is completely independent from the rest of the agreement and the matrix law that governs the agreement. However, if you look nowadays to the arbitration clause that you see in the state mineral agreements, you will see that those arbitration clauses quite systematically refer to a dispute resolution mechanism or dispute resolution forum that is specified from the beginning, and that may be located in Africa and not outside Africa. And you will see that the substantive law that must apply to the dispute is also specified and not left to the discretion of the parties when the dispute is settled, or left to the discretion of the arbitration tribunal. So which means that there is an expectation on the side of the state that the law of the state, of the host state, must apply as much as possible, even in case of a dispute that is settled by international arbitration. So we can see more and more a restriction of the freedom of the parties in that regard, in particular in the modern generation of state mineral agreements that have been negotiated in the past 10 years in many parts of Africa. So as you can see, that fragmentation, that competition between legal instruments of a contractual nature and legal instruments of a non-contractual nature has an effect on the freedom of the parties when they want to negotiate projects agreement. And it is my last slide, that multiplicity of legal instruments and the non-contractual nature of many legal instruments applicable to mining has also an impact in terms of ownership rights, mineral ownership rights, and corporate ownership rights. If we talk about mineral ownership, we will see that most of the time the question of the ownership of the mineral resources, the conditions under which the mineral resources can be owned, can be covered by a mineral title, and the conditions under which this title itself can be owned, transferred, signed, mortgaged when mortgageability is applicable. All those conditions will not be governed by the project agreement. They will be governed by legislation. And therefore, one of the fundamental questions about the feasibility and the funding of a mining project, which is a question of the ownership of the main assets of a project, the mineral resources, will actually depend on legal instruments that are not of a contractual nature and that are different from the main project agreement that is negotiated by the sponsors. So if we look at corporate ownership, we can see the same trend. Very often, you will not be able, the private company, won't be able to negotiate under the project agreement all the conditions relating to the equity structure of the project company, because it will have to apply concurrently the provisions that deal with state participation in the mineral legislation, in the foreign investment legislation, in the local content legislation when there is one, and also sometimes in the constitution itself. In addition, in certain African countries, a big part of those conditions, corporate conditions, will not depend on the local laws, the pieces of legislation that are applicable by your state, but will depend on those treaties that have been negotiated as regional level and deal with corporate and commercial matters. So this is true here again in the UADA, which is the UADA region, which is probably the area where we have achieved the most advanced level of legal integration between the different member states. So the UADA Act on Corporations and Commercial Law includes provisions regarding the rights of shareholders in commercial companies that necessarily override the provisions that can be included in the mineral legislation and even the project agreement. And very often there is a conflict, by the way, between what the provisions you find in the mineral legislation are and what you find in the UADA Uniform Acts. So as you can see, here again, even in relation to the conditions that apply to the project company itself, and not simply the project or the mineral resources, you have an interference of rules that are not contractual rules, are not even rules that are under the control of the host state. So that's what I wanted to show, to explain that this fragmentation is not only a source of complexity, it's not only a source of conflicts, it's not only a source of disputes, but it has an immediate impact on the definition of the rights that the project company may acquire and preserve in terms of contractual rights and also ownership rights. Okay, so I think this is what I wanted to cover during this presentation. And now I think I'm happy to take any questions.
Thank you so much. Thanks, Guillaume, for your incredible mapping of the complexity that we have currently with these various instruments that end up making up the legislative or rather just the functioning legal landscape, functioning maybe in inverted commas, for a lot of mining projects. It's really fascinating to hear the layout of the land, I suppose, to use that metaphor. We have a question here from Alec. Given that there are all these conflicting laws and norms across nations, does it not call for an internationally sanctioned law framework for mining where nations may be signatories, or is there already such a framework in existence?
Yes, so actually it is true that this complexity explains why there has been a trend for the standardization of legal instruments. So we can see that process regarding the state mineral agreements. This started actually in Asia, in PNG, for instance, where in the past the mining projects were primarily based on project agreements that were all different from a project to another. There was gradually the requirement to apply a standardized model of project agreement to the mining projects, and this started in the 90s. So we have seen that evolution in PNG, for instance, and also in Indonesia to a lesser extent, but we have seen that in Africa too, and in particular in many countries where the reform of mineral legislation was funded and directed by the World Bank, and where there was a requirement to attach to any new mineral legislation a standard state agreement. That should be the model followed by all the mining companies when they want to conclude a project agreement with the state, with the result that this standard agreement, the project agreement that is actually signed, doesn't vary from a company to another, and is less and less of a contractual nature, because if it becomes a standard, it is less and less of a contractual nature, and because it applies to, when the same provisions apply to all the different companies, and that standard agreement looks more and more like a regulatory instrument. But this shows you that there has been an attempt to standardize this type of legal instrument. In terms of mineral laws, there has also been an attempt to harmonize the mineral laws. A good example of that, but I don't see many examples in Africa, but there has been one single attempt, which is the common mining code that applies to all the member states of the Western African Monetary Zone, which is headquartered in Ouagadougou in Burkina Faso. So the UMOA, so that monetary zone authority has issued a common mining code that applies to all its member states. So that monetary zone authority is completely different from the OADA, which is itself a source of complexity. But it is an organization that has pushed all its member states to adopt a common mining code. But those member states have accepted and ratified that mining code because that mining code is very, very short, very superficial, and naturally doesn't regulate a lot the mining sector, and of course it's not sufficient to regulate the mining sector in all the member states. So which means that in all those member states of that monetary zone, you need to apply not only the mining code of the host state, but also that regional mining code. So, but in terms of integration of the mineral laws, that's really the main example. That's only the only example I think we have in Africa. We may see in the future a common mining code for the member states of the SADC area, but I think it will take a lot of time for all those African countries to agree on a mining legislation that would apply to different member states. Because even if you look at countries outside Africa, there are not many examples of legal integration of the mineral legislation Yeah, it's quite difficult to achieve that because, as you know, in many countries, either the mining business is not significant, so there is not an incentive for a sovereign state to agree on an international treaty that would govern mining in different member states, or the mining business is a fundamental part of the economy, and in that case, it is so sensitive that it is impossible for the host state, politically at least, to sell the idea that the law that should govern mining should be negotiated with neighboring sovereign states.
Thanks, Guillaume. We have two more questions that I'd like to get through. We've got three more questions, sorry, to get through before, so in the next 3 minutes. But I think the one you have kind of spoken to quite a bit now, but I think just to give a few sentences on this from Kennedy, we have, as a follow-up for the previous question, what will the impact be, if any, of the increasing trend of regionalization in Africa in terms of developing rules and regulations around project development and project finance? Also, the effect of the African Continental Free Trade Agreement comes into effect. Kennedy has another question that I think I'll just ask you at the same time. What would be the position in the event of conflict between national laws / rules and the regional rules, or conflict between regional codes?
Okay, so regarding the first question, as I've said, there is a trend, there is actually an expectation that there could be more integration at regional level. And I've given the example of that mining code applicable to the member states of the Western African Monetary Zone. So it's an example of integration of the different mineral laws. And I've explained that there are not many other examples because it seems to be difficult to harmonize those laws dealing with natural resources, which is a matter of sovereignty at supranational level. Precisely because the ownership of mineral resources is a matter of sovereignty. So I'm more confident in the ability of the regional organizations that exist in Africa to harmonize the investment laws, the banking laws, the corporate and commercial laws. And this is what the OHADA has been able to achieve. This is what the SADC it may be able to achieve, for instance. And they are considering that legal integration model. But I think they have probably in mind those laws that deal with corporate and commercial matters. I mean, the type of matters that apply to all industrial sectors and not necessarily mineral resources exclusively. And we can see, it is true, I forgot to mention it, but regional integration, if not continental integration, in terms of competition laws, foreign investment / competition laws. And this is why we have seen legal integration in terms of competition laws that within the SADC region, in Western Africa as well. And we are just really at the beginning of the process because they are actually appointing more and more officials within the regional West African Competition Authority, precisely to apply those free trade agreements. And we can see integration at continental level with the free trade agreement that is envisaged at continental level. So yes, there is certainly a growing integration, but on the one hand, we have growing integration in terms of laws and treaties, but on the other hand, we have also a growing fragmentation because we can see, for instance, a growing number of pieces of legislation that apply to mining. So all the ministers in all the different African countries want to be involved and they want to regulate what they can regulate. So, and in most of the African countries, we can see more and more pieces of legislation applicable to mining. So 30 years ago or 20 years ago, even the environmental provisions were primarily controlled by the Ministry of Mines. So it's no longer the case. Now the Ministry of Environment tends to apply environmental laws to mining independently from what may be the positions of the Ministry of Mines. So, so there is a growing fragmentation for the reasons I've explained, but also because there is a growing decentralization, transfer of powers, transfer of resources from the central state to the decentralized authorities. So we have both trends at the same time. On the one hand, growing integration, but on the other hand, a growing fragmentation. So that's what I can say about the first question. Regarding the second question, which is how to resolve conflicts between national laws and non-national laws and supranational laws, but precisely it's a quite complex matter because most of those laws that are not enacted by the national parliament qualify as treaties or supranational legal instruments, and therefore this is no longer a matter that belongs to the national legal system of the host state, but it is a matter of private international law, where you need to apply private international law, the rules of conflict of laws, as a part of private international law, and also international arbitration law. So, and here, very often, the conditions under which you can actually resolve this type of conflict will require not only to look at the rules of conflict of the internal legal system, but also the rules of conflict that apply internationally, and where a big part of the decisions would actually lie in the hands of international arbitrators who are foreign to the state, who very often won't apply the law of the state to resolve that type of conflict. So, this is why this type of conflict will be resolved in many different ways, depending on how the rules of conflict apply. So naturally, another important factor that will matter to resolve this type of dispute is the Constitution and the type of constitutional provisions that may be included in the Constitution precisely to help the national authorities to resolve conflicts between the national laws and the national treaties, for instance. But very often, whether you look at the mineral legislation or the Constitution, you won't find provisions that help you to resolve all the different conflicts, because you can have conflicts between the project agreement and international treaty, but you may have conflicts between the national pieces of legislation and the national treaties. But you can have conflicts between the Constitution and international treaties. Very often, the Constitution will never incorporate provisions that actually recognize the overriding status of international rules, and very often the Constitution will always prevail if you look at the Constitution. So this is why it is extremely difficult to find a solution that could be fixed in the national laws or the Constitution or even the national treaties regarding the type of conflicts that may occur.
Thanks, Guillaume.
It is so important to ensure that the due diligence conducted prior to the negotiation of agreements in a particular country, covers not only the legal instruments that are applicable at national level, but also includes a section on the different international treaties that will apply. Otherwise, some dispute risk may be ignored or underestimated.
Thanks, Guillaume. We have some questions coming in, and I'm just concerned about time. So if we can limit the answers to 2 or 3 sentences each, because I do want to close the session quite soon. Sorry about this.
Okay.
So we've got 2 questions from Anonymous. Firstly, thank you for your presentation, very fascinating. Can you say that mergers and acquisitions are therefore more complex based on your observations?
Oh, definitely, because very often, I mean, the mergers that are likely to succeed are mergers between companies that may be located in different states, but neighboring states, or they may also be very difficult to arrange because very often mining companies may be located in the same state, but they might not be subject to the same regime because of the impact of stability clauses. You may have a company A that is subject to a mining code or mineral legislation that was enacted 10 years ago and still applies to that company. But the company B, which is just on the other side of the river or the border of the first mining project, will be subject to another regime, to another mineral legislation. So this is why it's so difficult to arrange mergers, because very often the two companies to be merged are not subject to the same legal regime for many different reasons.
Thank you. And then we have the next question from Anonymous. Has there been cases you have dealt with where institutional investors have pulled out of projects because of these complexities?
Yes, where I would say where that type of complexity led to conflicts between different authorities that had jurisdiction. So there are some projects that were not funded because there was an opposition that couldn't be resolved between the Ministry of Finance and the Ministry of Mines, for instance. So I've seen that.
And then our last question from Magnus. From your experience, when is the best time in a project to make provision for the establishment of a legal framework for a mining project? Before prospecting, pre-feasibility, feasibility? When would it be best?
Well, it becomes absolutely necessary when you move from exploration to mining, because this is really where you need to raise a big amount of finance to fund projects. So it may be premature to embark on this kind of engineering at prospecting and exploration stage. However, this matter is so complex that you cannot really review it and manage it in a few months. So it is really advisable to start that exercise at least when exploration is well advanced and when you are likely to move to the pre-feasibility stage, not even the feasibility or bankability stage. So you need to start that due diligence process at that time, I would say. Naturally, if the sponsor are prepared to invest even earlier, it's even better. But it requires a big investment because, as I said, it means a very big due diligence that needs to involve many different specialists, not only at local level, but also at international level. So it may be a quite big and expensive exercise.
Thank you. And then one last question from Anonymous. Do you offer mentorship?
The mentorship to whom?
It would appear to Anonymous.
No, because that complexity in itself is very often ignored or underestimated, even by the lawyers who advise the lenders, the sponsors, or the in-house counsel. So many of the issues are ignored or underestimated before a project is actually project agreement is agreed, and they materialize later. And this is why we have so many disputes and so many arbitration disputes related to natural resources projects. So it is true that if it's not easy for the lawyers involved, it's even more difficult for the managers who are not lawyers, for the CEOs who have no qualifications to deal with these issues and certainly don't have time to deal with these issues. It's also difficult for the officials and the administrations and even the ministers. So when we embark on discussions about the conflict of laws between national treaties, constitutional provisions, mineral codes, agreements, well, this type of discussion is only accessible for specialized lawyers. So it is true that all the different people involved, all different leaders involved in the management or the control of mining projects, they need mentorship. And certainly, I'm very happy to participate into this type of exercise. And this is what we do within our firm, naturally. But certainly, it is true that mentorship is needed. I would say that training is also needed, because precisely a big part of those issues is not known or understood correctly by the project managers, the executives of the mining companies in developing projects, or even the members of the administration.
Okay, thank you so much. I will definitely share the presentation, and of course, you can find Guillaume's presence on the ENS Africa website, and you can contact them directly for this mentorship request. Otherwise, thank you so much for joining us on your Wednesday afternoon. And thank you so much, Guillaume Blanc, for your presentation. It was really insightful, and we've received quite a few comments just thanking you. And I'd like to pass that on. Just thank you so much for your presentation. And I hope you have a lovely afternoon further. Thanks, everyone.
Thank you. Goodbye.